Here's a criminal law and procedure hypothetical that is beautifully well written. This is the sort of hypothetical that you could very well see either on the multi-state or on an essay examination. Take a look at the four-part call of the question. 1. What factual and legal defenses are available to Doug? And if they are accepted by the jury, what crime, if any, should Doug be convicted? Discuss. Well, that's not very helpful, but we know that the prosecution is going to have one or more theories of liability, and presumably Doug is going to have some factual and legal defenses. We'll put them together and see how it all adds up. 2. If Doug is convicted, how should the appellate court rule on the argument that the prosecutor's actions during jury selection denied Doug's rights under the 6th and or 14th Amendments to the U.S. Constitution? We know that a criminal defendant has a right to an unbiased jury that also is representative of the community. We'll have a look at what the prosecutor did, and then we'll judge whether or not it lives up to constitutional standards. 3. If Doug is convicted of first-degree murder as charged, and the jury is instructed that it has no discretion as to penalty, would imposition of the death penalty violate the 8th Amendment? Answer, yes. We don't even need to read the fact pattern to be able to answer call of the question number 3. An automatic death penalty sentence violates the 8th Amendment, and it's just that simple. Now, to write an effective essay answer to call of the question number 3, we can't just write the word, yes, it's a violation. We've got to specifically explain what the circumstances are, but the bottom line is the 8th Amendment prohibits the automatic application of the death penalty. It's very clear-cut. Finally, question 4, did Jane act lawfully when she shot Al? Discuss. Well, wait a minute. This is an entirely new killing, it appears. So we'll have to look at the facts carefully. And we're not asked whether or not Jane has committed homicide. We're asked whether or not she has acted lawfully. That's rather interesting. So we go to the top of the question, and we see we've only got 3 paragraphs for the entire fact pattern. And that length is considered fairly short, both on the multi-state and on the essays. So let's have a careful look at it. In paragraph 1, we meet Jane, and we find out that she is a plainclothes police officer, and she's attempting to make a lawful arrest of Al for distributing drugs. Doug didn't know either Al or Jane, and he shows up on the scene in a poorly lit alley and doesn't realize that Jane is a cop. Because Jane is wearing civilian clothes and holding a gun on Al, Doug thought that Jane was robbing Al. Now let's pause for just a moment and consider paragraph 1. Here we meet the entire cast of characters. Doug comes on the scene and is the witness to what he thinks is a robbery. Is there anything about this paragraph that makes us suspect that there's something the matter with Doug's conduct? So far, no. And we also can anticipate factual defenses, which is he obviously doesn't know that Jane is an officer, and he doesn't know that Al is a criminal suspect whom Jane is trying to arrest. So look at paragraph 2. Here, Doug runs up and shoves Jane, and the result is that Al tries to get away. Jane fires one shot at Al, killing Al. All right, now just wait a second right there. Now we look at call of the question number 4. Did Jane act lawfully when she shot Al? It looks as if the answer to that question is no, because Al was not being arrested for a violent felony, and he didn't pose the sort of immediate threat to the community that violent felons can pose. Now, I think we could all come up with fairly persuasive arguments that suggest that drug sales and the drug trade in general is not a peaceful affair. But still, drug sales is not the sort of violent felony that a deadly force can be used to stop a fleeing felon. So it looks as if our short answer to question 4, did Jane act lawfully when she shot Al? It looks as if the answer is no, she didn't, because he was not the right type of fleeing felon that would justify deadly force. But look at the very last sentence of paragraph 2 in the fact pattern. Here we see Doug wrestling the gun away from Jane and shooting Jane, killing her. And now we find out about the homicide that Doug is being charged with. Let's take a careful look at the facts. Doug arrives on the scene. He sees what appears to be a robbery in which the victim, the suspect, was being threatened with deadly force. At the moment that Doug pushes Jane, that battery appears to be justified based on the defense of others. And the fact that Doug doesn't know Jane as a police officer probably is a fairly good defense. But then he wrestles with Jane, and a careful reading of the facts suggests that what happens is Doug takes the gun away from her and then basically executes her with it, as opposed to having the weapon discharged while the two of them are struggling over it. So, looking at this paragraph, it appears as if Doug's killing of Jane is unlawful despite the fact that she was a police officer, because once he has disarmed her, she no longer poses a threat to him. And so killing her at that point would be obviously going several steps too far. Now, paragraph 3, we find out about the aftermath of these two killings. Doug is indicted for murder of Jane under a statute which mandates imposition of the death penalty for first-degree murder of a police officer who is in the performance of her duties. During jury selection and over Doug's repeated objections, the prosecutor uses peremptory challenges to remove African Americans and death penalty opponents from the jury. And then we get the 4-part calls of the question. Well, as it turns out, all of these calls of the question are giving rise, essentially, to short answer questions. And exactly these issues regularly are presented on the multi-state bar examination as well. So turn the page and have a look for a few minutes with me at the outline of issues, and let's flesh it out a little bit so that our analysis would be grounded in the law, but narrowly and specifically focused on the facts. We are being asked in question 1 about Doug's defenses to homicide. And he's got 2 broad defenses, those being defense of others and self-defense. And as we've indicated in our consideration of the fact pattern, Doug's defense of others can go to the extent of shoving Jane. But after he shoves Jane, Jane shoots Al and kills Al. So at that point, Doug no longer has any right to defend Al because Al no longer exists. Al's dead, lying presumably face down on the street. Now, after Jane has shot Al, Doug's next line of defense would be self-defense. He's got no idea Jane is a police officer. She's already killed one person. I think that at that point, Doug could be reasonably concerned for his own life. So with regard to the struggle for the weapon, here again, I think Doug is on reasonably secure ground. Presumably, he still doesn't know that Jane is a police officer, and he's already seen her kill one person. And if the gun were to discharge during their struggle for it, I think Doug would be on stronger ground than he probably is. My reading of the facts is Doug seized the gun from Jane and then just shot her, just executed her with the weapon. And that's not legal, and it goes beyond his right to self-defense. Because at the moment that he disarms Jane, she no longer poses a deadly threat to him, and he's not allowed to shoot her in self-defense. So now, let's look at Doug's criminal liability. The charge that he is facing is first-degree murder of a peace officer in the performance of her duties. It's quite evident that he's not guilty of that charge. First-degree murder is a creation of statute. It suggests some premeditation and deliberation, and I've just said he's clearly not guilty of that charge. But you know what? A fairly persuasive case could be made that he is guilty. As a judge, I certainly would not grant Doug a motion for a directed verdict on a homicide charge. At the time that he seizes the weapon from her, she no longer poses a threat to him. His use of that weapon in killing her is enough to satisfy the malice requirement because there's been a deadly weapon used. It's also possible to form the requisite intent of premeditation and deliberation in just a matter of a few seconds' time. So conceivably, Doug could be convicted of first-degree murder of a peace officer in the performance of her duties. But I think that the better result is he's not guilty of that charge because he didn't premeditate and because he didn't know that Jane was a police officer on duty. But how about homicide liability in general. Sure, he's probably or arguably not guilty of the first-degree murder charge. Is he guilty potentially of second-degree murder? Answer, yes, because he has used a deadly weapon to kill somebody. However, I think that probably the wisest result would be that Doug would be guilty of manslaughter. And the reason is his defense of others and self-defense justifications for the killing aren't good enough, but his mental state probably is sufficient for him to be able to establish that he really is not a murderer and that his imperfect self-defense would justify lowering the charge to manslaughter. But certainly Doug is going to face some criminal liability. As I've suggested, one could make a case that he's guilty as charged, but I think it's far more likely that he'd be guilty of a lesser charge, either second-degree murder or a form of manslaughter based on an imperfect self-defense. Now we turn to the prosecutor's conduct during jury selection, and here we have to analyze two things, and we'd analyze them separately. First, it appears as if the prosecutor is showing evidence of racial bias, kicking black folks off the jury over the repeated objections of the defendant. It's likely that this would be found to violate the defendant's right to a fair trial. With regard to the prosecutors using peremptory challenges to kick off death penalty opponents, the prosecutor is almost certainly on reasonably secure ground. She's not trying to kick them off for cause, but it is okay for a lawyer on either side in a criminal case to use politics as a way to discriminate between a juror that you want to keep and a juror that you want to get rid of. Certainly, if we were talking narrowly, different from the facts in the question. Suppose we're looking at a prosecutor who is kicking off death penalty opponents from the penalty phase of a capital trial. Under those circumstances, the prosecutor would be justified in kicking off death penalty opponents for cause, not using a peremptory challenge. But at the guilt or innocence phase, it seems likely that the prosecutor's conduct of kicking off death penalty opponents would survive scrutiny on appeal. Next, we look at the mandatory death penalty call of the question, and here we really didn't need to read anything more in the fact pattern to know the answer to this question. A mandatory death penalty violates the Eighth Amendment on its face. Sure, we'd talk about the Eighth Amendment up front a little bit. We would discuss the defendant's right to present not exactly exculpatory evidence, since we would be dealing with a convicted defendant at that point, but certainly any argument that the defendant wants to make that could justify sparing his life is an argument that the defendant has a constitutional right to make. And any statutory scheme that forbids a defendant from arguing to spare his or her life is void under the Eighth Amendment. So we conclude that the mandatory death penalty sentence is violative of the Eighth Amendment. Then, the last call of the question, did Jane act lawfully when she shot Al? The answer is no, because Al was not the sort of violent felon that deadly force is justified on the part of law enforcement when the felon flees. And that concludes a discussion of a very well-constructed, well-written criminal law and procedure hypothetical. You'll see language strikingly similar to the language in this question, both on the multi-state and on essays.